between the Government of Australia and the Government of the Republic of Korea. I now welcome Dr. Matthew Rimmer, Associate Professor, ANU College of Law. For the Hansard record, would you please state your full name and the capacity in which you're appearing before the committee?
I'm Dr. Matthew Rimmer. I'm appearing in a private capacity.
Excellent. For the sake of Hansard, although the committee does not require you to give evidence under oath, I should advise you that this hearing is a legal proceeding of the Parliament and warrants the same respect as proceedings of the House and the Senate. The giving of false or misleading evidence is a serious matter and may be regarded as a contempt of Parliament. At the conclusion of your evidence, would you please ensure that Hansard has had the opportunity to clarify any matters with you? If you nominate to take any questions on notice, could you please ensure that your written response to question reaches the Committee Secretariat within 7 working days of the receipt of today's transcript? Do you wish to make any introductory remarks before we move to questions?
Yes, thank you.
Over to you.
So my submission is upon the Korea-Australia Free Trade Agreement. And really, I kind of consider the question about whether such agreement opens Australia for business or whether it opens Australia to litigation. And in particular, in terms of my kind of submission, I talk about the Kafka-esque nature of KAFTA and the very secretive negotiations that took place in relation to the Korea-Australia Free Trade Agreement. And much like some of the other trade agreements that we've seen in the past, there have been kind of issues in terms of lack of transparency, lack of independent analysis, limited public consultation and participation in the negotiations, particularly without the benefit of the text. Really, there should be a time to revisit the operation of treaty making in the Australian Parliament. I think the trickled treaty reforms that kind of took place in the 1990s have really been quite broken and have been working very well. My submission then kind of goes on and talks a little bit about market access and the kind of debate about whether or not the agreement is a comprehensive trade agreement or whether it's much more limited in its scope. A large part of the submission looks at investor-state dispute settlement, ISDS, and really the submission argues that investor clauses are a risky business. And you can kind of see that looking at the international developments in relation to investment agreements. So if you look at the statistics of UNCTAD, you can see a kind of a sharp rise in the numbers of investor actions being taken around the world. Such actions have been very diverse and have covered a wide range of different issues. So most notably in Australia, there's been a lot of controversy over our plain packaging regime being challenged under an investment clause with Hong Kong by Philip Morris. But there's also been disputes in a wide range of other areas. So Canada at the moment is busy fighting on drug patents against Eli Lilly. There's been lots of issues in relation to the environment. There's lots of issues in relation to the agriculture. So there's been a great deal of controversy about the operation of investor-state dispute settlement. Unfortunately, the investment chapter in relation to the Korea-Australia Free Trade Agreement fails to resolve some of the problems in relation to those mechanisms. So the chapter has a very broad definition of investment. You could really drive a Kia truck through the definition of investment, and that's quite problematic in the sense that a wide range of different investors could make use of this kind of particular clause in Australia. There have been kind of issues in terms of the kind of the breadth of the regime being kind of put forward. And I guess there's also kind of concerns about the rather spectral nature of the exceptions and defences in relation to investor-state dispute settlement. So that's a large part of the submission. I also talk a lot about intellectual property and the intellectual property chapter. I guess a key part of my submission is that I'm really kind of concerned about the interlinkage between investment rights and intellectual property. So intellectual property owners are given superpowers under the Korea-Australia Free Trade Agreement, in addition to their normal range of civil and criminal remedies that they can seek in relation to copyright law and trademark law and civil remedies in relation to patent law. Intellectual property owners can really bring actions in relation to investor-state dispute settlement because they are defined in terms of intellectual property rights as coming within the scope of the investment agreement. It's notable that Stephen Harper's government in Canada has been very concerned about that after being kind of attacked by drug companies through that mechanism. So I'm kind of very concerned about that interlinkage. The intellectual property chapter has been the subject of quite a bit of debate in terms of the public media. I guess there's a concern that really the agreement embeds in an anachronistic old template in relation to copyright law. So it tries to lock in Mickey Mouse copyright term extensions, the kind of broken old mechanisms of technological protection measures and electronic rights management information. A lot of controversy about what was said in the national interest analysis about the significance of the agreement in relation to the ongoing controversy between Roadshow and INET. So there's a very kind of peculiar bit in the national interest analysis which makes the rather strange assertion that the Australia-United States Free Trade Agreement, the Singapore-Australia Free Trade Agreement and the Korea-Australia Free Trade Agreement kind of demands major copyright reforms in relation to authorisation and limited liability for intermediaries. So you might know there was a huge High Court of Australia battle in 2012 between Roadshow and INET, which was won by INET quite convincingly. It seems that there's a bit of a push by copyright owners in a number of submissions to try to argue that those range of agreements demand stronger protection for copyright owners and a greater range of action against intermediaries like internet service providers. And looking at the kind of agreement, I don't really see the textual basis for those assertions. So I'm a bit concerned that some of the copyright owners are trying to make a devious end run around the Parliament by trying to kind of smuggle arguments that we should have a series of copyright reforms through such measures. So there's a lot there in relation to copyright law, and there's a lot more kind of detailed information there. Patent law is really kind of significant because Korea is a patent superpower, particularly with companies like Samsung, has massive investments in relation to mobile phones and televisions and a whole wide range of other kind of products, and they've been diversifying out into other areas. And there's been huge global patent wars between Apple and Samsung. So I'm kind of quite interested in terms of, the impact of the patent regime, in terms of the relationship between Australia and Korea and some of the other battles that are going on. The submission also talks a little bit about trademark law. In addition to those major parts, the submission also kind of looks at some other kind of key areas. So it kind of looks at some of the controversies in relation to investment clauses and public health. So as you know, there's been a huge amount of controversy over big tobacco challenging Australia's plain packaging regime. So the High Court of Australia ruled 6-1 in favour of the constitutional validity of Australia's plain packaging regime. The tobacco industry have then gone off and tried to challenge that regime of the World Trade Organisation. So there's 5 countries at the moment who are challenging Australia's regime in the World Trade Organisation on the TRIPS agreement, the Technical Barriers to Trade agreement. Big tobacco have also been trying to use investment clauses to challenge plain packaging of tobacco products around the world. But particularly they've kind of focused upon the investment clause between Australia and Hong Kong. And I was somewhat kind of concerned to read that Philip Morris has kind of shifted some of their operations off to Korea. So I think that's something we need to kind of consider. The tobacco companies have also kind of challenged graphic health warnings as well under investment clauses. So the now Prime Minister Tony Abbott introduced graphic health warnings when he was a health minister. Similar warnings in Uruguay have been challenged under an investment agreement. The Director General of the World Health Organisation, Margaret Chan, has expressed her opposition to the use of investor-state dispute settlement clauses by big tobacco against public health measures. She noted One particularly disturbing trend is the use of foreign investment agreements to handcuff governments and restrict their policy space. For example, tobacco companies are suing governments for compensation for lost profits following the introduction, for valid health reasons, of innovative cigarette packaging. And she went on and said, in my view, something is fundamentally wrong in this world when a corporation can challenge government policies introduced to protect the public from a product that kills. So huge controversies internationally about investment clauses and their operation in relation to public health. Apart from that, the submission looks a little bit at the environment and labour rights. So in relation to environmental matters, I guess there's a concern that it's quite a weak, toothless environmental chapter in the agreement. It does little to protect the environment, but the agreement does kind of provide investor clauses to a wide range of kind of companies. And I think the next speaker, Kyla Tenhara, has written a whole book on the expropriation of environmental governance and how mining companies particularly have kind of deployed investor clauses. Quite a bit of debate in Australia about some Korean mining companies in New South Wales getting involved in controversies. So, you know, one way to think about investment clauses that they could be used in that sort of context. Final part of the submission deals with labour rights. Again, the chapter on labour rights is quite weak. So if there was a kind of controversy over labour rights, it's not really going to be a mechanism to address those concerns. I kind of note in the last days, Samsung has been involved in huge controversies, much like Apple, over children allegedly being kind of involved in the manufacture of its products in China. So some Korean companies have been kind of caught up into issues about labour rights and child rights. But that's just a kind of an overview of my kind of submission. But I guess the debate over the Korea-Australia Free Trade Agreement is also kind of pertinent for some of the other big debates coming up. So I think there's also an inquiry on investor-state dispute settlement more generally, and there's a kind of a larger debate about the Trans-Pacific Partnership